Hi and welcome to this latest immigration law update video. I've called this video Mind Your Gaps, and this video is all about Rule 276B and the case law in relation to both current overstaying and historic gaps in your lawful residence. Now, I've done a couple of videos on this before. I've done a video looking at the case of Ahmed. I'll link my old video below this video, and I've also had an immigration law conversation with Gary McIndoe about this subject, and I'll also put the link for that below this video. But on the 22nd of October 2020, we got the judgment in Hoque and others from the Court of Appeal. It's on your screen. It's 2020. Here's the citation: EWCA Civ 1357. Now, this is a complicated judgment, and the court was split on the interpretation of 276B. So what I'm going to do is I'll try and give you the headline and tell you exactly what the court decided, and then I'll go through the judgment and give you some more detailed analysis. But hold on to your hats, because this is a complicated area. And you can see the Court of Appeal were not happy again with the drafting of the immigration rules and made some very stark comments about the rules themselves. But if you follow along as I go through on my screen. So Lord Justice Underhill gave the leading judgment. And in relation to his interpretation of the rules, Lord Justice Dingemans agreed with him. Lord Justice McComb didn't agree with them, and he actually favoured the appellant's interpretation of 276B. In fact, just to summarise, they all agreed, though, on the interpretation in relation to Article 8. So these were 5 linked applications for permission to appeal. Some of them raised issues under Article 8, you'll see from paragraph 3. So let's have a look at the relevant rule, 276B. It's an application for ILR on the basis of 10 years continuous lawful residence. So you'll see we've got 5 elements to the rules. Roman 1A. He has at least he has had, and that's important because it's historic, he has had at least 10 years continuous lawful residence in the United Kingdom. 2, no public interest reasons. No general grounds. 3, knowledge of English language and life in the United Kingdom. And then Roman 5, which is the sort of, along with 1A, are the key paragraphs that we're going to look at. And what Lord Justice Underhill has done is he's labelled the different parts of Roman 5, A, B, and C. So as you're following along the judgment, remember that A, B, and C are not, in fact, parts of the rules. It's his labelling to make life easier. A, the applicant must not be in the UK in breach of immigration laws, except that where paragraph 39E of the rules applies, any current period of overstaying will be disregarded. C, any previous period of overstaying between periods of leave will also be disregarded where A, the previous application was made before 24th November 2016 and within 28 days of the expiry of leave, so that's the old 28-day grace period, or B, the further application was made on or after the 24th November 2016 and paragraph 39E, that's the new 14-day grace period, of these rules applied. Now, let me at this point in the video summarise what the Court of Appeal find. The Court of Appeal find that the case of Ahmed was wrong, but they do find that the case of Ahmed was correct in terms of what it said about B. What does that mean? Well, the court finds that each of these elements are distinct. 10 years has to be, he has had, it's past tense. You've had to have had established your 10 years continuous lawful residence. 39E is a grace period in which you can make your application, but it doesn't extend your leave. You can't reach 10 years by relying on 39E. So that's why they approve what was said in Junaid Ahmed. But they disagree with Masoom Ahmed and find that C, the historic gaps, what they call book-ended gaps, this actually is bad drafting, and C doesn't relate in any way to Roman 5, but actually relates to 1A, the historic 10-year period. And your continuous lawful residence is not broken if C applies, that you've got these disregards there that apply to you. So you've got these two kinds of gaps. You've got the open-ended gap, so that's current overstaying, and you've got this book-ended overstaying, historic gaps. 39E, the current 14-day grace period, it's a qualified grace period, is set out there at paragraph 14. He then sets out the facts of the cases. I don't need to go through that. Now, the issue at paragraph 20, that's important because these guys, their last period of limited leave expired before they reached 10 years continuous lawful residence. And they didn't make an application in time, so they didn't have little 2, 3C leave. But they did make a further application within the 14-day period, or in the case of Hoque, within the 28-day period. And they subsequently varied that to an ILR application because they reached their 10-year anniversary. And that was ultimately refused. So these were cases of open-ended overstaying. They'd overstayed before they'd reached their 10 years lawful residence. Now then, Lord Justice Underhill looks at the two previous cases, Junaid Ahmed and Masoom Ahmed. So Junaid Ahmed is a decision of the Upper Tribunal from Mr. Justice Sweeney. And then Masoom Ahmed is a permission to appeal decision from the Court of Appeal from Lord Justice Floyd and Lord Justice Haddon Cave. Now, as we'll see, Junaid Ahmed related to open-ended overstaying. So Lord Justice Underhill cites what was said at paragraph 75. The parties are rightly agreed that paragraph 276B of the immigration rules sets out 5 separate requirements. For the reasons advanced by Mr. Malik summarised above, I conclude that 1, given the definition of lawful residence in paragraph 276AB, it is hopeless to argue that the appellant could meet the first requirement under 276B1A. In that case, he was somebody who hadn't reached 10 years lawful residence, and he was an open-ended overstayer. It is obvious from the structure of paragraph 276B, read in conjunction with paragraph 276D, that paragraph 276B Roman 5 is a freestanding additional requirement to subparagraph 1A, and consistent with the general amendment of the immigration rules to the effect that applications for leave to remain by persons who have overstayed for more than 28 days will be refused on that ground. There is no arguable merit in Mr. Biggs' contention that the applicant was to be treated for the purposes of paragraph 276B as if he had leave to remain and thus to be in lawful residence, nor in the contention that the respondent's construction would lead to starkly unfair results to applicants. Rather, it is readily foreseeable that if the applicants were to be so treated, it would create fertile ground for the abuse of the system. So in that case, it rejected the argument that applying within the period of the open-ended overstaying exception, that's 39E or previously 28 days, that didn't create lawful leave and get you to 10 years lawful residence. Masoom Ahmed was different. That was a case of the book-ended overstaying. They were lawful when they applied, but they had these historic gaps of short periods of book-ended overstaying. And the Secretary of State argued that those periods of overstaying meant that the period of his lawful residence was not unbroken as required by paragraph 276AA. The claimant argued that the two gaps attracted the operation of paragraph 39E and therefore failed to be disregarded under 276B Roman 5. The upper tribunal rejected that argument, so they made an application for permission to appeal to the Court of Appeal. And the question was whether it was arguable that paragraph 276B5 operates so as to cure short gaps between periods of leave to remain, so as to entitle persons such as the applicant in the present case to claim 10 years continuous lawful residence under paragraph 276B1A. And the court holds at paragraph 15 that subparagraph 5 of 276B does not have that effect. So it says the critical point is that the disregarding of current or previous short periods of overstaying for the purposes of subparagraph 5 does not convert such periods of lawful leave to remain. Still less are such periods to be disregarded when it comes to considering whether an applicant has fulfilled the separate requirement of establishing 10 years continuous lawful residence under subparagraph 1A. So what in Masoom Ahmed, what the court said is that subparagraph 5 doesn't help you in terms of subparagraph 1A. And they say it will be apparent, therefore, that we agree with the decision and the reasoning of Mr. Justice Sweeney and Junaid Ahmed, as Sweeney J correctly held paragraph 276B involves a 276B5 involves a freestanding and additional requirement over and above the requirements of 276B1A. Now, paragraph 28, Lord Justice Underhill says, look, Junaid Ahmed and Masoom Ahmed are not binding on the Court of Appeal because Junaid Ahmed is a decision of the UT and Masoom Ahmed is a permission to appeal decision. So let's look at Lord Justice Underhill's analysis. He agrees that paragraphs Roman 1 to 5 of 276B are freestanding and self-contained. And the next sentence is important. Normally, it would follow that any disregard provided for in a particular subparagraph would only relate to that requirement, and thus the appellants cannot invoke the disregards in subparagraph 5 to remedy their inability to satisfy the requirements of subparagraph 1A. But there is serious problems in terms of subparagraph 5, and things are not as straightforward as that. So what does he say? Element A states the actual requirement which subparagraph 5 imposes, namely that the applicant must not be in the United Kingdom in breach of immigration laws. So it addresses, I'm not going to say what the party said, but it therefore addressed to the applicant's status at the moment of decision. That is so simply as a matter of language, but it is also consistent with the first disregard, element B, being concerned with any current period of overstaying. So Roman 5 in 276B addresses your current status. The applicant must not be in the UK in breach of immigration laws. By contrast, Lord Justice Underhill says 1A requires that the applicant has had 10 years continuous lawful residence. That formulation does not necessarily require that the lawful residence is continuing at the date of decision. No doubt, typically that would be the case, but it would also be satisfied in a case where the applicant has accrued the relevant period in the past, but has become an overstayer since then. In my view, the purpose of the requirement in subparagraph 5 is evidently to ensure that overstayers are not entitled to ILR in those circumstances, subject to the effect of the disregard. Hold on to your hats. I hope you're still with me. It is a deep judgment, but I'm going to work my way through it. Element B, then, is expressly an exception to that requirement. So, A, the applicant must not be in the UK in breach of immigration laws. That's about your current status. Then the next part, which he calls B, except that where paragraph 39E of the rules applies, any current period of overstaying will be disregarded. So B is a disregard to your current status, current overstaying. But there's a problem with C, because C says any previous period of overstaying between periods of leave will also be disregarded where, and then there's the A and the B, the 28 days, and then now the 39E. And what Lord Justice Underhill says is this is a mistake of drafting, because C doesn't apply to your current status at all and doesn't relate to subparagraph 5 at all. Actually, if C is going to have any effect at all, it applies. It's a qualification to 1A, the historic requirement that you have had 10 years continuous lawful residence. So you've got two choices, paragraph 35. You either give C no effect at all, which is effectively what happened in Masoom Ahmed, or you treat it as a drafting error, and actually it's a qualification on subparagraph 1A. And it's that latter position, that it's a qualification on 1A, that the majority favour. And he says, if you look at the drafting history, that favours this conclusion. And also, if you look at the Secretary of State's long residence guidance, that also favours this conclusion. Now, he says at paragraph 39, you don't usually, it's not legitimate normally to use the IDIs and guidance as a way to interpret the rules. Mahad said that, but one qualification to that is in Pockerell, and what was said in Pockerell is you can use it where a rule is ambiguous, like this, and the Secretary of State has in her published guidance adopted a more favourable interpretation to applicants. In any event, Lord Justice Underhill says I don't need to rely on the guidance for my conclusion. So he says, if I'm right, Masoom Ahmed was wrongly decided. Now, the Secretary of State originally sought to uphold the reasoning in Masoom Ahmed, but later on then accepted Masoom Ahmed was wrong. But what the Secretary of State argued through Ms. Giovanetti is that actually the fact that Masoom Ahmed is wrong doesn't help the appellants in this case, because that issue is to do with bookended overstaying, but these appellants are open-ended overstaying, and the C doesn't help at all with open-ended overstaying. And Lord Justice Underhill agrees with the Secretary of State that Junaid Ahmed was correct, although Mr. Justice Sweeney's reasoning is too broad because he applies it to both disregards. And Masoom Ahmed is wrong because it treated both book-ended and open-ended overstaying as if they were the same. So what does he say? The B, the first exception, applies to Roman 5. So your current status, you mustn't be in the UK in breach of immigration laws, except where paragraph 39E of the rules applies. That qualifies your current status, but it doesn't help you in terms of historically reaching 10 years. Whereas C relates to any previous period of overstaying, doesn't relate to your current status, but does qualify 276B1A about your historic establishment of 10 years. Now, the counter arguments raised by the appellants was, well, actually, no. Both disregards, B and C, both apply to the 10-year period in 1A. But Lord Justice Underhill rejects those arguments. So in conclusion, He says, therefore, I would hold that the requirement of continuous lawful residence in 276B1A is not qualified by by paragraph 39E disregard in element B of 276B5. So again, just to go over it once more, let me read to you 276B5. The applicant must not be in the UK in breach of immigration laws. That's current status. Except that where paragraph 39E of these rules applies, any current period of overstaying will be disregarded. So that first disregard applies to your current status, but can't be used to establish your 10 years. It can't make you lawful for 10 years. Then the next disregard, C, any previous period of overstaying between periods of leave will also be disregarded. And then A and B, that does apply to establishing the 10 years. Now, he then looks at the other issues and disposal, but he gives a postscript. And look at this postscript. The court has very frequently in recent years had to deal with appeals arising out of difficulties in understanding the immigration rules. This is partly as a result of their labyrinthine structure and idiosyncratic drafting conventions. But sometimes it's simply a matter of the confused language and or structure of particular provisions. This case is a particularly egregious example. The difficulty of deciding what the effect of paragraph 276B5 is intended to be is illustrated by the facts not only that this court itself is not unanimous, but that all three members have taken a different view from that reached by a different constitution in Masoom Ahmed. Likewise, the Secretary of State initially sought to uphold Masoom Ahmed, contrary, it would seem, to her own guidance, but as we have seen shortly before the hearing, executed a volte-face, open brackets. This illustrates a different vice, also far from unique, that the Home Office seems to have no reliable mechanism for reaching a considered and consistent position on what its own rules mean. Of course, mistakes will occasionally occur in any complex piece of legislation or quasi-legislation. But I have to say that problems of this kind occur too often. The result of poor drafting is confusion and uncertainty, both for those who are subject to the rules and those who have to apply them, and consequently also a proliferation of appeals. The Secretary of State has also taken the Secretary of State has already taken a valuable first step towards improving matters by asking the Law Commission to report on the simplification of the immigration rules. And I hope that action will be taken on those recommendations. But the problem goes further than matters of structure and presentation. And I would hope that thought is being given to how to improve the general quality of the drafting of the rules. Then you've got the judgment of Lord Justice McComb. Lord Justice McComb, he agreed with Manjit Gill on behalf of the appellants, and actually he applied both disregards to the establishment of the 10-year period, but he was in the minority. So he would have allowed the appeals in respect of the rules. He did, however, agree with the other members of the court in terms of the Article 8 arguments that they should be dismissed. At paragraph 96, he also is very strong in his criticism of the rules. He says, I entirely agree with what is said by Lord Justice Underhill in his postscript of paragraph 459. The problem, as he says, goes further than structure and presentation. After many years of trying to understand and construe implicitous drafting in various parts of these rules, and in simply trying to see how they're supposed to work in practice, I think there may be no solution other than to discard the present rules and to start again. It may take a considerable time to achieve, but the result should enable officials, migrants and their advisors, and the tribunals and courts to understand what is going on and should reduce the volume of litigation. That result, it seems to me, would be well worth it. Lord Justice Dingemans agrees with Lord Justice Underhill and his construction of the rules and the difference between the first disregard and the second disregard. Although interestingly, he initially was of the view that Masoom Ahmed was correct, but he subsequently came round to agree with Lord Justice Underhill. He then does an analysis of the Article 8 arguments and dismisses the Article 8 arguments, which I don't need to go through in this video. So a complicated judgment, but the takeaway is that these are separate requirements in 276B. The disregard in relation to 39E applies to your current position, and the disregard in relation to book-ended gaps, that does relate not to Roman 5, but to 1A and the historic establishment of 10 years lawful residence. Obviously, the Court of Appeal was split, so it may not be the final word on this, but that is the current position. And I hope that's been helpful in looking at this important judgment in the case of Hoque. Thanks for watching.